heard by ruling. You knew you had a daughter before you did all of these things. PR 225. Counsel state their appearances, please.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Dustin Fisher. Mr. Fisher does appear from Courthouse Security 3. Judge, this is a warrant to show cause. I would tell a court I have reviewed the warrant to show cause with Mr. Fisher. I would tell a court that he is going to stipulate to the following violations. First of all, there is an addendum report or addendum allegation that specifically that allegation has to do with Butler County Case 25 CR 161, where Mr. Fisher has entered a plea of guilty to possession of fentanyl, and that happened during a time when he was on probation in this case. He does stipulate to that and does have sentencing coming up on that. Further, he does stipulate that he has not paid fines, costs, and fees. He does stipulate that he has not provided proof of employment to his ISO. He further stipulates that on 2 other occasions, he did not report to the ISO police contact within 48 hours. Those are the stipulations he is making at this time, Judge.
Mr. Regier, is the state willing to drop the other allegations and accept the stipulation?
Your Honor, it would appear that on the record, counsel for the defense has indicated the defendant will stipulate to the violation in the addendum, as well as not paying fines, costs, fees, not providing proof of employment to the ISO, and not reporting police contact. The state has no objection to proceeding on those stipulations alone.
Your Honor.
Just a moment, Mr. Williams, or Mr. Fisher. I'll be right with you.
Yes.
All right. Okay, Mr. Fisher, the attorneys have told me that you're stipulating or agreeing that you violated the terms of your probation for the things that they mentioned. Is that correct?
Yes, Your Honor. For the not reporting the probation or to my probation officer that I had police contact, I didn't have a phone.
Hold on a minute. I'm going to give you an opportunity to make factors later on.
Okay.
I've announced my decision. Right now, I've got a few questions to be sure
Yes, Your Honor.
what you're doing. Mr. Fisher, do you understand that you have a right to a hearing where the state would have to show by probable cause that you no, a preponderance of the evidence. I'm sorry. Preponderance of the evidence that you violated these terms of your probation?
Yes, Your Honor.
Basically, the state would have a hearing where they would prove to me that you made these violations. So you understand you have a right to that hearing?
Yes, Your Honor.
And you understand that with the stipulation, you're agreeing to those violations and the court can sentence you. Looks like when you were sentenced in May of 24, Judge Webster gave you was it Judge Webster? Yes. Sentenced you to 8 months with a $200 fine. You understand that with your stipulation, you'd be waiving that right to that hearing, and you could be ordered to serve the remainder part of that sentence.
Yes, Your Honor.
Very well. Has anybody forced or coerced you in some fashion to make these stipulations?
No, Your Honor.
Have you had sufficient time to discuss this with Mr. Patterson?
Yeah.
All right. I do find that the plea or that the waiver hearing is knowingly and voluntarily entered with the advice of good counsel that there is, and I do find he's violated the terms of his probation as stated in those. The other allegations are dropped. and I will hear recommendations of the parties, starting with the state, then Mr. Patterson, and then finally Mr. Fisher himself. So, Mr. Regier, recommendations?
One moment, Your Honor. Your Honor, this appears to be the second request for revocation in this matter. The state's information is that previously a journal entry of probation violation was filed with the court. It would appear that this came before hearing back in June, where the court did where the court found that the defense stipulated to a number of violations. At that time, the court did order that the defendant serve a 48-hour sanction and then return to reporting probation for a period of 6 months. In light of it would also appear that the first hearing on the request for revocation currently before the court occurred approximately 1 month prior to today's date, and within approximately 3 to 4 months of the last request for revocation of probation was concerned. With all that being said, the state is recommending that the court pursue outright revocation, that the defendant be ordered to serve his sentence.
Very well. Mr. Patterson?
Judge, I am going to bifurcate the defense's request in this case and have basically two different requests for the court to consider. First one is a request for the court to continue the disposition in this case. The reason behind that request, Your Honor, is as stated and stipulated to by Mr. Fisher. He has a felony case set before Judge Rickey. That is amended information, 1 count, possession of fentanyl, level 5 drug felony. It's believed it's going to be Senate Bill 123 case. That case is set for sentencing on December 5th at 1 o'clock in front of Judge Rickey. Judge, there's a request by the defense to continue this to some date after that sentencing to determine what happens on his felony case, which could be information to be used to determine how long he should be in jail, Judge. If you think about Senate Bill 123, it's 18-month probation with requirements they get treatment and enter into treatment. That 8 months in jail first might severely interfere with his ability to become clean and a good community member. So we'd ask the court to, first of all, continue disposition. If the court elects not to continue disposition, Judge, we would ask the court to order a sanction and reinstate probation. The violations as listed, Judge, that he had 2 occasions of police contact, one in July and one in September 7, and that he had not reported that till September 19, according to this report. My client has told me he had some communication phone issues, that he reported those when he got into his probation officer. He tells me he is currently employed and can provide some proof of that. Judge, he is also, he has a wife at home or significant other, a child at home he is helping to raise. So a significant amount of time in the jail would probably hurt the entire family, Judge. So We are asking the court for a sanction, reinstate, or to continue this till after his felony sentencing. Thank you.
I'm going to deny the request for continuance, and I will make my decision today concerning revocation. So that request is denied. Mr. Fisher, is there anything you would like to advise me before I announce my decision?
Yes, Your Honor. I have obtained employment. I've been working with my brother-in-law. He has a plumbing business. It's the Real McCoy. And I've also been doing like, it's a side job, but it's scrapping metal with this guy that contracts through, I think I want to say Simmons Well Service. And like I have been working. That's what I'm trying to say. And I'm not trying to waive my responsibilities to what has took place. I know that with everything that at hand, I mean, there's certain circumstances that have hindered me from having successful, getting things done in an orderly time and doing things like in the fashion you guys want me to do them. There's a lot of factors in there that, I mean, are out of my control. And I mean, I'm not trying to deter my responsibility to the situation. Things have been rough. Let's say that. That's all I have to say.
Thank you.
Mm-hmm.
In reviewing your file, as noted, you on June the 16th, there was a revocation hearing. On that date, Judge Webster placed you, gave you a 48-hour consequence.
Yeah.
And okay, you don't need to respond every time I pause.
Sorry. I'm sorry, Your Honor.
You had numerous that you were unsuccessfully discharged from alcohol and drug counseling in February of 25, admitted to drinking alcohol, did not provide proof of employment, many of the same sort of behaviors that we're here today. In fact, here we are.
In fact, just like the last guy, you're one pathetic loser.
In October, and the motion to revoke was October, and we're here in November. I note that your offense was driving while an habitual violator, first conviction. To get a habitual violator, you have to have at minimum, three major violations on your driving history. And now you additionally have possession of fentanyl. I have, for the last 5 years, been hearing juvenile and, more importantly, not the care and treatment, but the cases concerning children. And when children's parental rights, I have had to officiate where children have watched their parents die, found their parents' bodies where they've overdosed from fentanyl, watched two of them that had watched Narcan bring a parent back, only to have that parent overdose again and die at a later date. I don't think I'm doing you any favors by letting you loose.
Your Honor, I haven't done fentanyl since February. I haven't done it since February, though.
Just stop. You have violated as many terms of a probation as I can recall seeing for a long time. See what your sentence was. You violated it. Judge Webster gave you another opportunity. And then what'd you go and do? You committed a felony. I am not going to release you. I'm going to order that you serve the remainder of your 8-month sentence. In that period of time, I hope you do get the treatment that you need and so feel under the influence of something and killing somebody, including yourself. I'm not putting this
I
up
have my
for
daughter,
argument,
Your Honor. I haven't done
Sir,
that at all.
sir, you've heard by ruling. You knew you had a daughter before you did all of these things. So I'm not going to use your parenthood as an excuse for what you're doing. I made the ruling. You are remanded to the sheriff's office to serve the remainder of your sentence. Good luck to you. The matter is adjourned.